Hello, everyone, and welcome to Uncivil Law, where, as always, we try to learn from the misfortunes of others. As always, I hope you'll enjoy this legal educational content, and today may be the day I earn your subscription. For today's coverage, we're going to be going through the jury instructions. This is going to be the law part. This is the good part. This is the part where we get to look at the law and we get to understand it. And I get to break it down for you a little bit. The jury instructions already try to do this, but I'll try to make some points along the way and try to understand exactly what legal questions and factual questions the jury is being asked to consider right now. So as I'm sure you all are well aware, the jury got the case this morning. They asked for a copy of the instructions, pages 1 through 6, and then asked for the rest of them. They asked for 11 copies because they had only gotten one. So that can suggest a whole lot of things. It can suggest a whole lot of things. It's very hard to read tea leaves from jury questions. It's a slight bit of a fool's errand, but we do what we can anyway. But what we can easily conclude is at least that they didn't finish today. And normally a really quick delivery is good for the defense. The idea being that in a complex case, the only way for it to come, unless, it's just blatantly, obviously guilty. But in a complex case, the only way for the jury to come back fast is for them to say not guilty. Because otherwise, they'd have to look through a lot of different things. So if they can short-circuit the whole process by saying not guilty, that's usually what gets you done faster. So you can have quick guilty verdicts, of course, but that's usually where the evidence is absolutely overwhelming. But you wouldn't expect that here. So what we do know is the jury got the questions and they're looking at it. So we also know from tweets and speculation and rumor and hearsay that there are apparently 2 jurors who are holdouts, apparently concerned about potential retribution in the community or to themselves. I mean, who knows? Who knows how accurate that information is? I'm not particularly thinking it's reliable, but it's better than the nothing we otherwise have, so I guess. Anyways, we are going to read through the jury instructions. We're going to try to understand it. So I'm sure all of you guys know the facts fairly well at this point. So, let's talk about the law and let's ask the actual legal questions the jury is being asked to do. That's a good thing. Let's ask what the actual law is. Okay, great. Okay, so here is the document the jury got. It's 36 pages long, which I'd like to immediately just point out the obvious, is a legal nightmare, even for a lawyer. And so the idea that the jury is actually going to read or understand any of these things, let alone a lawyer be able to read or understand these things. 36 pages is a lot, man. That's a lot of legal stuff to keep in your head at one time. So the idea that jury is actually going to read this with a fine-tooth comb. Maybe they are. Maybe that's why they asked for the instructions. But will they really understand everything? Well, what we got. All right, so let's just read this and see what we got. All right, so here's what the jury hears. Members of the jury, the court will now instruct you on the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all these instructions, regardless of any opinion you may have about what the law is or ought to be, because, maybe the law should be something else other than it is, but it is what it is, right? You must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case, which have been properly proven by the evidence, considering only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. So just consider what you've heard inside the courtroom, which also includes these instructions, incidentally. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. Because the jury is a trier of fact. That is their job in life. You, the jury, are the sole judge of the facts, and the court is the judge of the law only. Information. And information is nothing more than a formal written accusation against a defendant charging the commission of one or more acts. So the information, so you just got to love this header right away. Information, not evidence. Because in the normal sense of the word information is like evidence is something. I can give you information. But no, we're using the word information in a legal sense, in a technical legal sense, as in the charging document. So you will hear this referred to as an indictment. An indictment comes from a grand jury. If it doesn't come from a grand jury, it has other names. States are not required to use grand juries. Only the federal government is required to use grand juries. States sometimes do use grand juries. So you will see indictments from states. But more often than not, you get some sort of direct filing from the prosecutor. They just file it. And in this particular instance, they called it information. That's its technical name, the charging document. So hopefully that was clear right away, right? So this formal charging document is nothing more than a formal charge. It is not evidence. It does not raise an inference of guilt. It's just an accusation. The charges. The information contains 6 counts. I believe it's 5, actually. I think that's a typo. But we'll get there. 6 counts of charged unlawful behavior against the defendant, and to each, he has entered a plea of not guilty, which is to demand the state prove every element of each charge beyond a reasonable doubt. The burden of proof is on the state. The state must prove each and every element of each charge beyond a reasonable doubt. If the state fails to prove even one element, then not guilty. So if you have a charge that has multiple different things, and the state fails to prove even one of those things, not guilty is the verdict. You can only come to guilty if the state proves all of them beyond a reasonable doubt. Privilege, self-defense. This is incidentally why the attorneys kept referring to it as privilege, because it's referred to as privilege in the documents. And it is privilege in a legal sense, because it is a justification that provides a privilege that otherwise couldn't be raised. It extends from a human right, but this is where things get complicated. Self-defense is an issue in this case. As to counts 1 through 5, the state must prove by evidence which satisfies you beyond a reasonable doubt defendant did not act lawfully in self-defense. Now, this is a little bit different than some states. This is the strongest version of this I've ever seen for the defense. Some states, it's preponderance of the evidence. I think every state except Ohio, the burden is on the prosecutor. I think in Ohio, it's on the defendant, which is pretty weird. So the defendant actually has to prove it in Ohio. But in a lot of states, it's only preponderance of the evidence. So it's not as high as other things. So you only have to disprove it to preponderance of the evidence, more likely than not. But here, the state or the defendant has to prove it to preponderance. But here, the state has to disprove it to beyond a reasonable doubt. So he does have self-defense. It is self-defense as a starting proposition. Your baseline is it's self-defense. The state has to disprove it beyond a reasonable doubt. Okay. General principles of self-defense. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed there was an actual or imminent unlawful interference with the defendant's person. So that's going to subjective belief. What did he think in his own head? Did he believe it? The defendant believed that the amount of force used or threatened to use was necessary to prevent or terminate the interference. And the defendant's belief was reasonable. That's going to objective. Objective. So 2 of those are subjective. 1 of them is objective. Did he subjectively have the fear? Did he subjectively believe this amount of force was necessary? And is that belief objectively reasonable? And then it goes on to the difference between deadly force and non-deadly force. The defendant may intentionally use force which is intended to or likely to cause death or great bodily harm only if defendant reasonably believed that force used was necessary to prevent imminent death or great bodily harm to himself. So self-defense is not just for murder. Self-defense applies into any kind of assault or battery. It could be a defense into simple assault, simple battery. It could be a defense in a lot of situations. But if you want to use deadly force, you can only do that in response to an imminent threat of death or grievous bodily harm. Otherwise, non-deadly force. This is one of the things the prosecution has been trying to argue with the whole like man up and just take a beating sometimes. I mean, strictly speaking, if all that was going to happen was he's going to take a beating, as long as that beating is not going to be of a grievous harm, right? So if it's a simple assault, there's no you can't use deadly force. You'd have to respond with non-deadly force. But then again, we're looking at this from the position of the defendant and what a reasonable person would believe. And the state has to disprove it. So, you know, and also, of course, if you believe Kyle's testimony that Rosenbaum had threatened him, said he was going to kill you, right? That would go a long way to feeding your belief of why that particular amount of force was necessary. Determining whether a belief is reasonable. A belief may be reasonable even though mistaken. You can be reasonable and mistaken at the same time. You don't have to be right. In determining whether defendant's beliefs were reasonable, the standard is the ordinary man. The standard is the person of ordinary intelligence and prudence, which would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. As a practical matter, this means the jury. Who's the reasonable man? The jury's the reasonable man. So all they have to do is ask themselves. The reasonableness of defendant's beliefs must be determined from the standpoint of the defendant at the time of the acts and not from the viewpoint of the jury now. This cuts both ways for both sides, right? All the defendant can rely on is what he knew then. This is a large part of the reason that the prior bad acts by some of the people Rittenhouse shot are not brought into evidence. Why didn't the jury ever hear about him going to a mental hospital? Why didn't they ever hear about past convictions? Why didn't they ever hear about those things? Well, the answer is because Kyle didn't know that at the time. Kyle can't get lucky, and he can't get unlucky. The only thing that Kyle can rely on, for better or worse, is what he knew at the time. So what did he know? No. Well, what he knew is what was happening in terms of people's actions. He had no way of knowing these people in terms of their background. He didn't know these people. No evidence of that. No evidence that someone brought their background specifically to his attention. So that's part of the reason, right? Kyle can't rely on things he didn't know. And the jury also can't work from the benefit of hindsight. They have to go into Kyle's mind at the time. There is no duty to retreat. However, in determining whether defendant reasonably believed the amount of force was necessary to prevent or terminate the interference, you may consider where defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. So this is a very confusing instruction. You have no duty to retreat, but in considering whether the amount of force is reasonable, you can consider whether or not retreat is an option. So could you have retreated in safety? Was that retreat feasible? Did you know about it, but you have no duty to retreat? Which is a very odd and confusing instruction. Wait, do I have a duty to retreat or not? Let's assume that I have the opportunity to retreat. Let's assume that I have a retreat that's feasible. Let's assume that I knew of this opportunity, but I chose not to take it because I don't want to. Does that make my Doesn't that make my further actions more or less reasonable? This instruction's a little confusing in that respect, to my mind. Provocation. You should consider whether the defendant provoked the attack. So this is the really dangerous instruction, right? Because the jury could potentially latch onto this if they misunderstand what legal provocation looks like. This is one of the reasons that getting the gun charge dismissed was such a huge win for Kyle, assuming the jury cares. Because if he was in possession of an illegal gun, although it shouldn't be viewed as provocation because it's not, legally, it's not. Illegal possession of a gun is illegal possession of a gun. It's not provocation by itself, not for at least the reasons that the person that you would be provoking can't know whether the gun is legal or not. They look the same. A legal gun and an illegal gun look the same. So how could the fact the gun is illegal be provoking? Because how could they know that? Again, going into everyone's mind at the time, what did they know then? What could they know then? But if that charge had stuck, a jury could get lost. They might still get lost because they heard about it forever, but that's why getting struck was such a big deal. A person who engages in unlawful conduct of a type likely to provoke an attack. I see I have a super chat. Jacob gives me $5. I'm going to beat you, but only to the extent you're not gravely injured, is what all criminals yell out as they try to take your gun. I mean, I'm just telling you the law. All right, so yeah. $4.99 from Swanson. You always do a great job. Thanks for your work and time. And as always, let's go, Brandon. True that, my friend. True that. There's also $5 from the Denialist, who said, since the walls may be thin, would it be hilarious if a court could hear a juror talk about how they won't convict because of the prosecutor lied? It would be hilarious, too. Very good. Thank you for the super chats, as always. However, if the attack which follows causes the person to reasonably believe he's in imminent danger of death or great bodily harm, he may act in lawful self-defense. But the person may not use or threaten force intended or likely to cause death unless he reasonably believes he exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. So, if you provoke it, you're not allowed to use deadly force. But if the person attacks you and you have no ability to retreat, apparently you do, which is kind of confusing. $5 from Body Ba. Appreciate seeing you on Nick's stream. I'm glad I found you there. Thank you very much, Bloody Ba. I appreciate your super chat. Thank you. Yeah, the provocation instruction is just weird. Because if you provoke, you're not allowed to use self-defense against the attack you provoke unless the nature of the attack is deadly, in which case you can, if you have any reasonable ability to retreat or otherwise avoid it. It's a weird instruction. It's a weird instruction, in my view. All right, so crimes requiring intent. Counts 4 and 5 require intent to kill. So intent is a legally precise word. No Date gives me $5. Thank you for giving me some support. I appreciate that. So intent is what we call a mens rea term. Mental state. Mental state. We have two big things in law, in criminal law in particular. We have mens rea and actus reus. Mens rea means mental state. Actus reus means the act done. Usually you have to have both. You have to do a thing with a particular state of mind. There are 4 different kinds of states of mind, although there are 4 major kinds of states of mind. Sometimes statutes add other ones, but the major ones are intent, knowing, reckless, and negligence. Intent, knowing, reckless, and negligence. So if you just do a thing without one of those mental states, it's probably not a crime. And if you have the mental state, but you don't do the thing, it's not a crime. So you can have all the desire in the world to kill somebody, but if you don't actually, try to do something, your mere intent is not enough. And the mere act by itself without the intent is not enough. You need both. So intent is a mens rea word. $5 from E. Unum Pluribus. Back in the 70s, my dad sawed off a shotgun to use as a cannon firing wax slugs. He claims he didn't know it is illegal. Well, we all know ignorance of the law is not an excuse, but ignorance of the facts can be. Ignorance of the facts can be, but not ignorance of the law. Because when you talk about ignorance of the facts, you're talking about what you know. And if you don't know something, then you don't know that fact. So ignorance of the facts are often a defense in law. So let's talk about this high standard, intent, which is also called purpose. Intent to kill means defendant had the mental purpose, the design, the goal. It was their mission to take the life of another being, or was aware his conduct was practically certain to cause the death of another human being. So I desired to do it, or I knew it would occur, which kind of is knowing, to be quite honest. So intent to kill means also apparently knowing, because practically certain to cause death of another, that's knowing, right? So there is technically a difference. There is a legal difference between knowing something will kill somebody and intending to kill somebody, right? So if I shoot a bullet at you, and I shoot a bullet into your heart, there is a slight technical difference between I want you to die and I know you'll die, but I just don't particularly care either way, right? There's a very slight difference between I want you to die, that's why I'm shooting you, and I don't particularly care whether you die or not, but I know this will kill you. It's just not my design or desire to kill you. It's just I know that it's going to happen, but it's not really what I want for. There is a distinction there. It's intent versus knowing. So they got you covered on both of those, in case you're wondering why they're writing it that way. When intent may exist. While the law requires defendant acted with intent to kill, it does not require intent to exist for a particular length of time. This is true. It doesn't require it to be like a long-held intent. The act need not be brooded over, considered, or reflected upon for even a week, a day, an hour, or even a minute, or even really, strictly speaking, a second. You just have to form it at some point prior to the act. There need not be any appreciable time between the formation of the intent and the act. You can form an intent to kill pretty fast. The intent to kill may be formed at any time before the act, including the instant before the act, but not actually, strictly speaking, during the act. Right? It has to precede the act by some length of time. Any length of time would be fine, and must continue to exist at the time of the act. So again, this is calling into some minds of some differences, right? So strictly speaking, right? Again, you could have the intent to kill somebody and then not perform the act and then lose the intent but kill somebody, which might be a different charge, right? So it's not like it's scot-free, right? It's just not the charge you're reading at that particular moment. So if you're looking at like intentional murder, if you're looking at intentional murder, I formed the intent to kill you. I have formed that intent to kill you. I have it in my desire in my heart. I want you to die. And, I have a gun. And, I decide, but I don't decide to kill you. I want to kill you. I really do. But I don't perform that act, right? So, if somehow I lose the intent to kill, because, I'm like, I think better of it. I don't want to kill that guy today. I think better. So now I have the gun in hand and I have it pointed at you, right? So I have the intent to kill. I have the gun pointed at you. And I say, in my own mind, I say, I don't want to kill you anymore. So I put the gun down and the gun goes off by itself. Yeah. So strictly speaking, right, I didn't have the intent at the time I shot you. That doesn't mean I'm not guilty of anything. It just means that I'm not guilty of the intent to kill because I didn't have it at the moment that the act occurred. Of course, this all exists in a legal vacuum, right? This is all legal vacuum. So you have to get a jury to buy this as a this is true, which is why the jury is a trier of fact. But in a legal vacuum, like where we just get to assume things into existence, that's a legally correct result. Right? Good luck convincing a jury on that, but that would be right. $4.99 from Julie Gems. No date says, my question didn't go through. If Kyle had a handgun in his waist and he pulled it on the same situation, does he still get the same prosecution? I mean, presumably. I don't see why him having a handgun versus a rifle would make any difference to the prosecutor. It would change his argument, but not in ways that would matter. So it wouldn't matter. Revolt Power gives us $2. Thank you. Deciding about intent. You cannot look into a person's mind to find intent. Intent must be found, if to be found at all, from acts, words, and statements, if at all, if any, and from the facts and circumstances in the case. So yeah, how do you determine what someone thinks in their mind? Right? This is the difference between legal vacuum and the real world. Right? In a legal vacuum, where I get to just assume reality because it's my hypothetical, right? Since I lost the intent, I'm not guilty. But every action I did would seem to indicate to you that I had the intent. So how's the jury supposed to tell the difference? Good question. That's a great question. Someone gave me $2. Revolt gave me $2 to say, why didn't disparity of force? Use a force expert here. Why didn't disparity of force what? I don't understand the question. Let me carry on with the instructions. Okay, intent versus motive. This is such a tough one. And this is a tough one for lawyers. Lawyers screw this up all the time. All the time. It is a tough one to keep straight. Intent versus motive. It's really hard. All right, so I'll give you my personal favorite example to illustrate the difference between intent versus motive. Okay? Motive is the reason you're doing something, by the way. Intent goes to intent goes to your desire to do the thing. Intent goes to what? Right? Intent goes to what? Motive goes to why. Right? Intent goes to what you did, and motive goes to why. So here's my personal favorite example to illustrate the difference. A person goes into a bank. They slip a note to the teller. They say the bank is being robbed, give me $10,000. They show a gun. The teller slips them some money in a bag. They walk out of the bank. Now, what was their intent? Well, based on all the actions I described, their intent appears to have been to rob the bank. What was their motive? Why were they doing it? I don't know. Neither do you. You might say it's obvious. They were doing it for the money, you idiot. It would be a funny prank they want to film and put on YouTube. Maybe they were doing it to impress a girl. Maybe they are a security consultant who's fallen on hard times, and they're not really interested in the money so much, but they're interested in showing how vulnerable banks are, so people will hire them as a security consultant, so their business will get better. That's the difference, right? Why did he intend to do it? He did it. Well, why did he intend to do it? We don't ask. What is his intent? To rob the bank. His motive is why. So many reasons. Pick your favorite. Pick another one. Yeah. He thought it was a reality show. He thought it was a movie set. I don't know. Moody Morgan gives me $5 and says, what do you think the jury not being done with deliberations? It's hard to tea leave juries. It's hard to figure out what's going on, to be honest. It's a very strong temptation. It's extracting information from jury deliberations is notably tricky. Alex gives me $10 or 10 Australian dollars, I believe. Why wouldn't the simple presence of gun on your person when under attack constitute as a deadly situation? No. Is a gun on your person when under attack deadly? No, not necessarily. No, not necessarily. I mean, it has the potential to become deadly, but it doesn't mean it is deadly. Is it reasonable to assume a fistfight could end in the attacker getting the gun? I don't know. Maybe. That's what you ask juries for. Is it reasonable or not? I was just describing the legal vacuums, or I'm trying to float between the two. So I don't blame anyone if they're getting a little bit confused by the frames of reference, because I'm floating between legal vacuums and reality. Like in a legal vacuum, if Rosenbaum is merely chasing Rittenhouse, merely with the intent to beat him up a little, that doesn't imply grievous bodily harm. I mean, so in a legal vacuum, Rittenhouse wouldn't have self-defense. If you all knew that, but that's one of the things about legal vacuums, right? In a legal vacuum, I get to declare all the rules. I'm God, and I just get to tell you what's true, and then all the law that follows flows out nicely, right? Because I just get to declare reality. I'm like, oh, in reality, because I'm God in this hypothetical, in reality, Rosenbaum was just trying to beat him up a little bit. That's all he wanted to do. Okay? I was like, oh, well, in that legal vacuum hypothetical reality, right, then you can't use deadly force. But then, of course, we move back to the real world, and we say, okay, well, that's why we ask about reasonable persons and reasonable beliefs, even if they're mistaken. Because Rittenhouse doesn't have to be right. He has no idea what's going on in Rosenbaum's head. Neither do I, except so much as it's my hypothetical, my rules. But in the real world, I don't. So Kyle can only base things off what he knows, and given that he had a death threat from him earlier that day as being chased down, the question is it reasonable for him to believe what he believes, even if that belief is mistaken? Right? So that's how you kind of separate that. So I don't know if it's 100% clear when I'm floating. I don't know if it's 100% clear when I'm switching between real world and legal ideal vacuum world, but I'll try to signpost it clearer. Sorry, why didn't they argue disparity of force? They tried. They did. They didn't really bring in experts for it, but they definitely mentioned it. 6K sub increase means we must do a 12-hour Call of Duty stream, as you mentioned earlier today. Yeah, maybe. So if you're not an absolutist on the first, where are your ideas on restrictions on the first? Well, I don't have time for that. I don't have time for that. I think the absolutist position might be a little bit far, but I don't have time to get into the finer points of the First Amendment. But we'll move on. Intent should not be confused with motive. While proof of intent is necessary for conviction, proof of motive is not. This is true. Motive is not a legal part of the charge. We never have to show why someone did something. Why they did a thing is not part of the crime. Motive refers to a person's reason for doing something. While motive may be shown as circumstance to aid in establishing guilt, the state is not required to prove motive. Evidence of motive does not establish guilt. Motive is not an element of the charge. The state doesn't have to show it. They don't have to prove it. Even if they do prove it, it doesn't really actually prove anything by itself. It might be circumstance that might show an intent, right? So if you could somehow determine his motive, it would explain why he did the thing, right? If you somehow determined it's for the money, why he went into the bank and put a gun up to their thing, it's like, well, it helps in that respect, as opposed to an accident or a mistake, right? I'm not sure what that would be, but yeah, I guess it would separate it from that. So, in our bank hypothetical example, right? If you could somehow establish his motive is for the money, then then it would help separate the possibility that the defendant did it by mistake, a fact, right? The defendant robbed the bank by mistake, a fact. What might that be? Well, maybe he thought it was a movie set. Maybe there are two banks really close to each other and they look the same, and one's a movie set and one's not. And he's an actor and he's paid as an actor, and he went into the wrong bank Mistake of fact. You know? But if you have somehow established, oh, he needed money. Oh, okay. Well, that probably wasn't why then. It probably was for the money. Denialist gets $5 to say proof Uncivil is a better God than I. When I try these legal hypotheticals to see if I understand, I keep getting unclearer and I don't know. I try to do my best over here. I try to do my best. All right, so let's get into the first count. Reckless homicide, which is such a strange charge. Because one would think intentional, but we're going to go with reckless. The first count of the information charges that on or about Tuesday, August 25th, on or about is such wonderful legal language. We do it all the time. On or about Tuesday, August 25th, in the city of Kenosha, Kenosha County, Wisconsin, the defendant recklessly, mens rea, recklessly, caused the death of Joseph Rosenbaum under circumstances which show utter disregard for human life. First-degree reckless homicide is committed when one recklessly causes the death of another, being under circumstances that show utter disregard for human life. This is a strange charge. Why they didn't charge him with intent is beyond me. Intent is actually easier to prove in some ways than recklessness, right? Because he aimed the gun at him and pulled the trigger. It wasn't by he didn't hit Rosenbaum by trying to shoot somewhere into the crowd and hit Rosenbaum. That would be reckless, right? He was just shooting his gun wherever and the bullet hit him. That would be reckless. I think the facts support intent. So why are they charging reckless? I don't understand. So here's the things they have to prove beyond a reasonable doubt. The defendant caused the death of another. Cause means the defendant's act was a substantial factor in producing the death. This should sound similar from the Derek Chauvin trial with George Floyd. Substantial factor. Not only factor, not major factor, not principal factor, substantial factor. Maybe there were other factors that led to Rosenbaum's death. I don't know and I don't care. For the same reasons I don't know and don't care when it came to George Floyd's death. Maybe George Floyd was under drugs. Maybe he had a weakened heart. Don't know, don't care. Only question I am asking is the person in either case a substantial factor? The defendant committed a criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created unreasonable and substantial death or great bodily harm. Knowledge. He was aware. He knew. The circumstances of the defendant's conduct show utter disregard for human life. In determining whether circumstances show utter disregard for human life, consider these factors. What the defendant was doing. Why the defendant was engaged in that conduct. How dangerous the conduct was. How obvious the danger was. Whether the conduct showed any regard for life, and all other factors and circumstances relating. Now, I'd like to note that strictly technically, under the literal reading of this law, because it's recklessness, which seems like an ill fit, you could actually acquit Kyle on the principal charge. You don't, technically speaking, have to even get to the defense of self-defense. Right? You only have to get as far as self-defense if he actually committed the underlying crime. But given these exact instructions, is it 100% clear given the exact instructions, mind you, because we have to apply the laws as read, the laws that exist, not as we want to be. Remember, the judge told us that. So is it 100% clear? Well, I think causal you got there. I mean, causal for sure, you got that. Criminally reckless, they caused a risk, the conduct created a risk of death to another person. Okay. The risk of death was was unreasonable and substantial. Well, was it truly unreasonable? I mean, defendant was aware his conduct created unreasonable and substantial risk? I mean, there's a slight edge in there that you could actually pick apart this thing if you really wanted to try. And then you go into utter disregard for human life and whether it showed utter disregard. And determining that, you have to consider what he was doing, why, how obvious the danger was, and whether it showed regard for human life. Well, given his control of his firearm and how controlled it is, you could actually even attack utter disregard if you were so inclined. There's an opportunity there, which is weird because if you just charge him with intentional, you wouldn't have these problems. But you charge him with reckless. Not 100% sure why on that one, to be quite honest. Jacob says, I don't like the term substantial factor because as an engineer it could mean anything as 1% of the cause could be considered substantial. You're playing in my ground now, man. You got it. Yeah, what's substantial? Is 1% substantial? If it's the last 1%, it is. Sure. Yeah. So yeah, is 1% substantial? That depends who you ask, I guess. Okay. If as to the first count, you're satisfied beyond a reasonable doubt that all three elements of this crime have been proved, and the defendant was not acting in lawful self-defense, you should find him guilty. If not, you must. I also find this interesting, where it doesn't say you must find him guilty. Instead, you should. And as the engineers in the room and the lawyers in the room will appreciate, there's a pretty big difference between should and must. All right? So if you find these factors, you should find him guilty. If you don't, you must find him not guilty. So the instructions, again, by their literal wording, it's like, well, jury nullification is technically contemplated by these instructions. All right? I should do that, but, I don't have to. I can do something else. Right? If I'm following these instructions, if I must do something, I must. If I should, maybe. I mean, again, it's a weird little note. You should find him guilty, you must find him not guilty. I just think it's an interesting thing. All right, so count 2 and 3, the information, which is again the formal charge, accuse the defendant of reckless endangerment. Although the elements of it are identical, the rules of self-defense, which apply to them, are not. And this is where things are going to get complicated in self-defense land. First degree recklessly endangering safety, as defined in the law, is committed when one commits a reckless act that endangers the safety of another being under circumstances that show utter disregard for human life. Before you can find the defendant guilty of first-degree reckless endangerment of safety, the state must prove evidence which satisfies you of the following. Defendant endangered the safety of another human being. The defendant endangered the safety of another by criminally reckless conduct, which looks at the same definition before. Conduct creates a risk of death or great bodily harm to another person. The risk of death was unreasonable and substantial. The defendant was aware that his conduct created unreasonable and substantial risk of death or grievous bodily harm, or great bodily harm, as they say it. I might say grievous interchangeably, just because that's the way I'm used to reading it. But great bodily harm, it means the same thing. Great bodily harm means injury which creates a substantial risk of death, or which causes significant permanent disfigurement, or which causes permanent or protracted loss of impairment of the function of any bodily member or organ, or other serious bodily injury. So yeah, great bodily harm, grievous bodily harm, take your pick. And head trauma is a classic example of a great bodily harm. The circumstances show utter disregard for life, and in doing so, consider all the factors we discussed above. Now we have a special rule of self-defense as to Richard McGinnis. This is where it starts to get complicated. $5 from Scott Gimble. Given the laws are what they are, do you believe he should get away with what he did? Well, I don't. I will contest your framing of the question. Get away with what he did. It implies a moral dimension. As to, I can answer legal questions. What does the law suggest, or what does the law require? So I think in this circumstance, given the burden of proof to the prosecution, I think that he's not guilty of the charge. The reason is because, as we've discussed up to this point, and I don't know how long you've been watching the video, but as we discussed in this video up to this point, the state has to prove each and every element of the charge beyond all reasonable doubt, and they have to disprove the affirmative defense beyond all reasonable doubt. So the baseline presumption going in is that he does have self-defense. That's your starting point. He does have self-defense. You have to work from there. And so you have to show he doesn't beyond a reasonable doubt. So, and we also looked at the standards that apply in self-defense. We looked at how they're subjective and objective from his viewpoint. Did he think he had a threat? Objectively, would a reasonable person feel a threat? And can you disprove that beyond a reasonable doubt? I mean, not to my mind. So given the way that the jury instructions are reading, given the way the law is written, I think that he's not guilty. But I wouldn't frame it as getting away with anything. That's not the right way to phrase the question in my mind. 499 says, we're talking about actions from Kyle. What laws did or did not, what laws did or didn't the individual attacking him carry out? They should be on trial for mob mentality. There are a lot of people in the crowd who might have committed crimes, but we can only evaluate from one person's point of view at a time. So if we were, I mean, because every person's point of view is a little bit different. So we can't really ask what crimes are the crowd guilty of. We'd have to ask it for each individual person and analyze it as to their own frames of reference. So, you know, that's a lot of analysis for a lot of different people. But I think you wouldn't have too hard a time showing that there are people guilty of various crimes that evening, if you were so inclined. All right, so let's talk about Richard McGinnis. There's evidence in this case defendant was acting in self-defense as did Joseph Rosenbaum. The fact the law may allow defendant to use force in self-defense to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct, which showed utter disregard for human life, but the defendant does not have a privilege of self-defense as to Richard McGinnis. This is a very confusing instruction. This is correct, but it's confusing. He doesn't enjoy a privilege of self-defense as to Richard McGinnis. This is correct. His privilege of self-defense, if it exists, is to Joseph Rosenbaum. It's just that privilege transfers. Intent follows the bullet might be a phrase you've heard before. Intent follows the bullet. So if his intent is to act in lawful self-defense as to Richard McGinnis, his intent follows the bullet. So yeah, he doesn't enjoy self-defense as to Richard McGinnis, but that's not really the right question, and it's confusing for that reason. The law of self-defense allows defendant to threaten or intentionally use the force against another if defendant believed there was actual or imminent unlawful interference with his person, the defendant believed the amount of force he used or threatened to use was necessary to protect the defendant, and the defendant's beliefs were reasonable. The defendant may intentionally use force which is intended to or likely cause death or great bodily harm only if the defendant reasonably believed the force was necessary to prevent imminent deadly bodily harm itself. This is such a confusing instruction. S.K. Wiseguard 2322. It appears now the prosecutors knew the identity of Jump Kick Man before the trial. Is this grounds for a mistrial? It's grounds for more than that, because I'm pretty sure that Binger openly said in open court that they didn't know the identity of Jump Kick Man. A lawyer, all lawyers have a duty of candor to the tribunal. A lawyer cannot lie to the court. And so you can't come flat out and say, I don't know who this is, if you know who it is. So, you know, if it comes out, so he has a problem. He has a problem by lying to a tribunal, maybe. And there's a Brady problem too, because this person might be able to offer evidence for the defense. So yeah, there's room for mistrial and perhaps more beyond that. To be honest, it's a potentially big deal. So now let's go back into whether a defendant's defenses are reasonable. A belief may be reasonable even if mistaken. In determining whether the defendant's beliefs were reasonable, the standard is a person of ordinary intelligence and prudence would have believed in defendant's position under the circumstances that existed at the time of the offense. The reasonableness of the beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. We have to put ourselves in his shoes at the time. You should consider evidence relating to self-defense along with all other evidence in the case, deciding where a defendant's conduct created unreasonable risk of death or great bodily harm to Richard McGinnis. If defendant was acting in lawful self-defense with respect to Rosenbaum, his conduct did not create unreasonable risk in another. This is a horrible jury instruction. Because it's like, it's not relevant, but it is relevant. The burden is on the state to prove beyond a reasonable doubt defendant did not act lawfully in self-defense, and you must satisfy beyond a reasonable doubt from all evidence in the case the risk was unreasonable. You should consider evidence relating to self-defense in deciding whether the circumstances of defendant's conduct showed utter disregard. The burden is on the state to prove beyond a reasonable doubt defendant did not act in lawful self-defense, and you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of conduct showed utter disregard of human life. If to these counts you find each element has been proven and not acting in self-defense, you should find defendant guilty. If not, you must find him not guilty. And now we get into these intentional homicides. I'm not quite sure again why Rosenbaum is reckless and these are intentional. But okay, we're going to charge him with intentional for Huber, but reckless for Rosenbaum. Seems like a strange thing to me. The defendant in this case is charged with first-degree intentional homicide. You must consider whether the defendant is guilty. If you're not satisfied the defendant is guilty of first degree, you must consider whether or not he's guilty of second degree, or first-degree reckless homicide, which are less serious degrees of criminal homicide. So first-degree intentional includes second-degree intentional, which includes first-degree reckless. So again, I'm not sure why you just didn't charge first-degree intentional with the lesser included, but I don't know. The crimes referred to as first and second-degree intentional homicide and first-degree reckless homicides are different degrees of homicide. Yeah, they're different levels. Homicide is the taking of the life of another human being. The degree of the homicide depends on the law, defined by law depends on facts and circumstances. While law separates homicides into different types and degrees, there are certain elements which are common. Both intentional and reckless homicide require a defendant cause the death of another. First and second degree intentional homicide require the state to prove the additional fact the defendant acted with the intent to kill. First degree reckless homicides require the defendant acted recklessly, and the circumstances of the defendant's conduct showed utter disregard for life. It will also be important to you to consider the privilege of self-defense in deciding the crimes, if any, defendant has committed. The Criminal Code of Wisconsin provides a person is privileged to intentionally use force against another for the purpose of terminating or preventing or terminating what he reasonably believes to be unlawful interference with his person or by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force, which is likely to cause death unless he reasonably believes such force is necessary to prevent imminent death or great bodily harm to himself. As applied to this case, the effective law of self-defense is the defendant is not guilty of any homicide offense if the defendant reasonably believed he was preventing or terminating an unlawful interference with his person, and he reasonably believed the force used was necessary to prevent imminent death or great bodily harm. $4.99 from No Date. Love that you wear the cowboy hat and don't overload the trial group with pointless chatter. You speak softly and carry a big scotch stick. Pour some scotch. Thank you. I prefer bourbon, but I do like the sentiment. Thank you. $4.99 from Daniel Jewell. How does Binger get fingered to be disbarred? I wouldn't bank on it, my friend. I think he's getting a promotion. It'll be Judge Binger before too long, and I wish I was kidding. $20 from Brent Caterino. Could the jury find not guilty on major charges but convict on reckless endangerment? It would be reversed on appeal. The mob gets a win in Kyle walks lair, passing the buck from the jury to the courts. You never bank on appeal. You never bank on appeal. You know, the self-defense lawyer guy whose name temporarily escapes me, who wants Dream, when I asked about the odds of appeal, he said, well, you assume the odds of appeal are 0. Which, you know, within a rounding error is probably pretty true for criminal cases. It probably is pretty close to 0. And then even if you do win, it's just like a do-over. So true wins on appeal are, like, really rare. You know, especially, and he pointed this out too, and I've said this many times as well, so it's nice to hear my own stuff echoed back. But, you know, innocent till proven guilty only applies until you're proven guilty. So if the judgment is guilty, innocent till proven guilty is over now. Right? So once you're on appeal, you're not talking about innocent till proven guilty anymore. You've been proven guilty. That happened. So now all the evidence has to be reinterpreted in weight of the verdict that happened. Right? Up until this point, up until the guilty verdict by law, by law, all evidence has to be interpreted in favor of the defendant. Because he's presumed innocent. All the evidence is interpreted in favor of the defendant. Once he's found guilty, it flips. All the evidence is interpreted in favor of guilt. Because innocent until proven guilty has already happened. So while I think that there are grounds of appeal, and some promising ones in overall context, I wouldn't bank on it. The self-defense lawyer's name was Branca. Thank you for the chat to remind me. £5 from Sierra Mary. Binger's proven himself to be a special brand of crappy person and may have single-handedly eroded trust in lawyers. True. Shut Up and Cook says, the law professor with wit and we won't snore. Yes, the hat, love it. And Sean Doyle says, law of self-defense. Thank you very much for that. I appreciate it. Excuse me. CZRNick 2 says, another engineer here. These seem designed to be confusing. Are jury instructions usually written in some hierarchical order? You start at the beginning, and if you get to an item, that's false, acquit. You know, between you and me, my kingdom for a flowchart, my undergrad is computer science, as I'm sure some of you know. So my heart beats deeply in sympathy with the engineers, because, you know, one of us kind of thing. But yeah, my kingdom for a flowchart. It's like, you know, they're written in an order that the law has determined through trial and error to be the right order. So, yeah, a flowchart would be nice though. JM gives $10. While not on topic, can you discuss direct appeals versus post-conviction motions? What happens when post-conviction motions are denied? Are you thinking like a JNOV as a post-conviction motion to overturn the verdict? Well, nothing happens. You appeal. So yeah, and I wouldn't expect a JNOV coming from this court. That's where the judge overrules the jury, by the way, in case of you who don't know the JNOV. It's when the judge reverses the verdict. It's judgment not in observation of the verdict, or that's the Latin, judgment not in observation of the verdict. In English, we say judgment notwithstanding the verdict. So, yeah. Anyways, let's press back on. Thank you for all the super chats and all the support, by the way. I do appreciate it from the chat and everyone that helps to make this dream come true. I really appreciate all the new subscribers. I really appreciate all the new supporters. I tend to go through things in a lot of legal depth, try to really analyze the law, really understand the legal aspects of what's going on. Sort of my little niche here in YouTube world. And I do appreciate those of you who really want to law geek out and really try to understand this stuff from the actual legal levels, because that's, you know, interesting to me. I'm glad it has it's interesting to you too. $1.99 from No Date. What impact does the jury being threatened have? Any? If you can document it. Engineers, unlike lawyers, are the only people on Earth who actually have to deal with facts. Facts cannot be manipulated when it comes to physics. Yeah, that's an interesting thing. I also do like the fact that my disciplines require two different sides of my brain. I do like that I have the computer science, physics, biology, engineering aspects of my brain, a little bit of electrical engineering in there, and where there's a reality and the bridge will rise or not. And then I also have the part of my brain where the answer to everything is maybe. I do like that sort of tension in my own mind between those two worlds, and it's fun for me, at least. Defendant is guilty of first-degree intentional homicide if defendant caused the death of another with intent to kill and did not actually believe the force used was necessary to prevent harm to himself. Defendant is guilty of first-degree reckless homicide if defendant caused the death of the other by criminally reckless conduct and the circumstances showed our disregard for life. And you'll be asked to consider the privilege of self-defense in deciding whether the elements of first-degree reckless homicide are present. Because the law provides the state's burden to prove all the facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has established necessary facts to justify a finding of killing for first or second-degree intentional homicide or for first-degree reckless homicide. If the state does not satisfy you as the facts, you will be instructed to find the defendant not guilty. The facts necessary to constitute each crime will now be defined in further detail. First-degree intentional homicide is defined as committed by one who caused the death of another with the intent /purpose /dream /desire to kill that person or another. Transferred intent. The intent follows the bullet. In this case, first-degree intentional homicide also requires the defendant did not actually believe the force was necessary. Note here, it doesn't have to be a reasonable belief. Here, it's only a mere actual belief. So this belief does not have to be reasonable, as it did in the case of the recklessness, which is maybe why they charged recklessness for Rosenbaum, because it has to be both subjective and objective. But in Wisconsin, for first degree, mere subjective belief is enough, even if unreasonable. Kindly. Okay. We do require people to be polite, so you do not get your super chat read, my friend. You go to the timeout box. Put them in the timeout box. No super chat for you. We don't let you do super chats to get around the rules. Okay, where was I? The elements of first-degree intentional homicide, that he caused a death and that it was a substantial factor, acted with the intent to kill another, and he did not actually believe. So this is just pure subjective belief. The third element of first-degree intentional homicide requires the defendant did not actually believe the force was necessary to prevent imminent death or grievous bodily harm to himself. This requires the state to either prove the defendant did not actually believe that there was an imminent danger of death or bodily harm. Defendant did not actually believe the force used was necessary to prevent it. When first-degree intentional homicide is considered, the reasonableness of defendant's belief is not an issue. You're only concerned with what the defendant actually believed. Whether those beliefs are reasonable is important only if you later consider the second degree. So again, reasonableness is not required for first degree. That's what that says. This is a little weird. Wisconsin's the only state that I know that does this, incidentally. I'm not aware of any other state that does this. But, every state can define their laws any way they want. So, okay. So first degree homicide. If you believe it subjectively, it doesn't have to be true. Objectively. So, hey, that's the law. If you want to go to lesser includeds, it has to be subjective, but not for first degree. Why is it weird? Just because I've never seen that before. I've never seen that before with that split. I've never seen it before. That's why it's weird. As to the fourth count, you're satisfied beyond reasonable doubt defendant caused the death of another with intent to kill, and defendant did not actually believe the force was necessary to prevent imminent death or grievous bodily harm, you should find the defendant guilty of first-degree intentional homicide. If you're not so satisfied, you must find the defendant guilty of first-degree intentional homicide, and you must consider whether the defendant is guilty of second-degree intentional homicide, which is a lesser included. You should make every reasonable effort to agree unanimously on the first charge of first-degree homicide before considering the offense of second degree. However, after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first degree. You should consider whether they're guilty of second degree. Second degree. They must prove the following elements beyond a reasonable doubt. The death was caused by another. They acted with the intent to kill. Defendant did not reasonably believe. Now we're going back to an objective standard. That it was necessary. You already be instructed on the cause of the definitions of cause and death and with intent to kill. The same definitions apply. Reasonable belief of force was necessary. The third element of second-degree intentional homicide requires the defendant did not reasonably believe he was preventing or terminating unlawful interference with his person, or did not reasonably believe the use of force was necessary to prevent imminent death or great bodily harm. I just realized I'm a total jackass. I mean, I probably knew that before, but yeah. I'm sorry, Stephanie. Yeah, that was. Yeah, I was mean to Stephanie the other night, and I was wrong. Well, I don't know if I just realized it, but yeah. Stephanie's great. I'm lame. Let's press on. Yeah. This requires the state to prove any one of the following. A reasonable person in the circumstances of the defendant would not believe that he is preventing or terminating unlawful interference with his person. Reasonable person in the circumstances of the defendant would not believe he is in danger of imminent death or grievous bodily harm. The reasonable person in the circumstances of the defendant would not believe the amount of force used was necessary to prevent imminent death or grievous bodily harm. The reasonableness of defendant's belief must be determined from the standpoint of defendant at the time of his acts, and not from the viewpoint of the jury now. I'm gonna quote Jordan Peterson on this one. I'm gonna paraphrase him on this one. You know, he has this one of these rules about treat yourself the way you want someone else to be treated, and I think a parallel version of that is treat someone else the way you would want other people to treat that person. And yeah, it's like I should basically don't be a hypocrite. It's like don't do the same thing that you would want other people to do. And yeah, that's yeah. Anyways, as the fourth count, you should be satisfied beyond reasonable doubt defendant caused the death of another with intent to kill, and not reasonably believe the force was necessary to prevent imminent death or great bodily harm. If you're not so satisfied, you must find the defendant guilty of second-degree intentional homicide, and you should consider whether the defendant is guilty of first degree. Now, I'd like to point out at this point, we're on page 16 of 36. We're on page 16 of 36, my friends. 16 of 36. And I have to be honest to you. My legal brain is beginning to shut down a little bit. Now, I don't know if that's due strictly to the length of this thing. or the time, or the amount of streaming I've been doing lately, or any of the other things. But I have to confess to you, my ability to legally process the things is beginning to become a little bit compromised. Because I'm actually trying to think about it really hard. And I just want to, again, emphasize this point that the jury has to try to understand this and consider this and keep this all in their head. Where are we getting this jury? Where are we getting this jury? That will be able to read this and consider this and analyze this at the level of depth that I think, frankly speaking, a murder trial probably warrants. Where are you getting this jury to be able to consider the things when I, as a lawyer who do this for fun, am getting a little burned out by page 16? Yeah. Okay. You should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, after a full and complete consideration of the evidence, you've concluded that further deliberation would not result in unanimous agreement on the charge of second-degree intentional. You should consider whether the degree is guilty of first-degree reckless. First-degree reckless is defined as one who committed by one who recklessly causes the death of another human being under circumstances that show utter disregard of human life. Before you may find the defendant guilty of first-degree reckless, the state must prove by evidence which satisfies you beyond a reasonable doubt the following three things are true. Cause means substantial cause. Criminally reckless means the conduct created a risk of death or great bodily harm, and the risk of death or great bodily harm was unreasonable, and the defendant was aware of that risk and disregarded it. You should consider the evidence relating to self-defense and determine whether the defendant's conduct created an unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt the defendant did not act lawfully in self-defense, and you must satisfy beyond a reasonable doubt that all evidence in this case that the risk was unreasonable. The circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider the following. What was the defendant doing? Why was the defendant doing it? How dangerous was it? How obvious was that danger? Did the conduct show any regard for human life? And all other factors and circumstances. You should consider the evidence relating to self-defense in considering whether the circumstances of the conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt the defendant did not act lawfully in self-defense, which, as for me, a lot, I can just kind of stop reading there, to be quite honest, because the burden is on the state to prove beyond a reasonable doubt the negative. The state has to prove the negative. They have to prove it beyond a reasonable doubt. They have to prove the negative. They have to prove that he did not lawfully act in self-defense beyond a reasonable doubt. This is the sentence that I can just read on and stop kind of reading, because, yeah. And he must be satisfied beyond a reasonable doubt from all evidence in this case the circumstance of the defendant's conduct shows utter disregard. $2 from Shut Up I Can Cook. Law Geek Out, awesome. What makes a good lawyer? Lots of different things make a good lawyer. I think the best trait for a good lawyer is the ability to consider multiple different sides and perspectives on a situation. I think one of the best traits for a lawyer is the ability to switch frames of reference in your mind. So, not for the least of reasons that you want to consider what your client, what the opponents to your client are going to do, and try to prepare yourself against it as best you can. Now, they're probably going to surprise you, 8 different ways, because you can't think of everything. But, you'll probably think of something and you'll be able to preempt it. So I think being able to think about things from multiple different points of view and multiple frames of reference is probably one of the most valuable traits for a lawyer. Really keeping your, keeping the debate open and being able to steel man the opposition. I think that's probably the best thing about being a lawyer, or one of the best traits. RB, was it legal for Huber Gage to attack Kyle because they heard others say he shot someone? Quite possibly, yes. It might have been legal for Huber and Gage to attack Kyle. Yes, but whether or not it's legal for Huber and Gage to attack Kyle doesn't go to the question of whether or not it was legal for Kyle. They can both be engaged in lawful behavior at the same time. Right? This is what I'm talking about when I'm talking about like switching frames of reference. Right? So if you want to switch the frame of reference to Huber, or you want to switch the frame of reference to Gage and ask for them as self-defense, okay, then, yeah, maybe. Given what we know, quite possibly. And for Jump Kick Man, for that matter, as well. But those conclusions about whether or not they were engaged in lawful self-defense has zero impact on Kyle, because we have to consider it from Kyle's frame of reference. So you have to make sure to keep these things straight in your mind. $5 says, thanks for standing up to the moderators. You're welcome. $5 from Jacob says, wouldn't it be better to have the jury first have to find the state disprove self-defense? Probably. I mean, that's what they're kind of supposed to do, but they're given all the instructions at once. They're all saying if you want to go back to bed and pick this up, we're all good with it, up to you. I'm going to try to press on. Do you think absolute immunity should be waived by the AG or governor? I'm actually not sure that's possible. I'm not sure it's possible for the AG or the governor to waive Benger's immunity. I don't know. I've never thought about it. Is if to the fourth count you're satisfied beyond a reasonable doubt defendant caused the death of another by criminally reckless conduct and the circumstances of that conduct showed utter disregard for human life and defendant's conduct was not privilege, you should find defendant guilty of first degree reckless. If you're not satisfied, you must find the defendant not guilty. Count 5, which I believe is the end of this rainbow. Yeah. Intentional first-degree homicide of Gage Groskowitz. Or do we have another reckless in here that I've missed? I think we have another reckless in here somewhere. Richie Brown says, been watching y'all for the last 2 weeks. Inspired me to start studying for the LSAT and going to law school. 40-year-old, but I'm excited to change. Well, don't worry, Richie. There are a lot of people in law schools doing second careers. Lots of people in law schools. About half my class was second careers. So you will be in no way out of place. So, have fun. Okay, so this is for Groskowitz. The crimes referred to as attempted first and second degree intentional homicide are different degrees of homicide. Homicide is the taking of the life of a human being. Can I do this? I can't do it from inside this window. That's lame. While the law separates attempted intentional homicide into 2 degrees, there are certain elements which are common. Both attempted first and second degree intentional homicide require defendant intended to kill another person. Defendant did actions which indicate unequivocally under all circumstances they formed the intent and would have caused death except for other intervention. So this is attempted homicide. The criminal code provides a person's privilege to intentionally use force against another under the following circumstances. Force is used for the purpose of preventing or terminating what a person reasonably believes to be unlawful interference with his person by another person. The person uses only the amount of force he reasonably believes is necessary, and the person may not intentionally use force which is intended to or likely cause death unless he reasonably believes such force is necessary to prevent imminent harm. $5 from Shut Up, I Can Cook. Tell people what to do, money or not. Do they talk to the police or not? Don't talk to the police, hire a lawyer. You find elements of attempted first or second degree intentional homicide. The effect of the law self-defense is as follows. The defendant is not guilty of either attempted first or second degree intentional homicide if the defendant reasonably believed he was preventing or terminating unlawful interference with his person, reasonably believed force was necessary to prevent imminent death or great bodily harm. The defendant is guilty of the attempted second degree intentional homicide. The defendant actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief of the amount of force used was unreasonable. Defendant is guilty of attempted first-degree intentional homicide if the defendant did not actually believe the use of force was necessary. So, did the defendant believe it, and is it objective in the opposite order? Because the law provides the state's burden to prove all facts necessary to constitute a crime, you'll not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you'll be asked to determine whether the state has proven necessary facts to justify a finding of guilt for attempted first or second degree intentional homicide. If the state does not satisfy that, you'll be instructed to find the defendant not guilty. The elements of each crime will now be defined in further detail. Before you may find the defendant guilty of attempted first degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt the following three elements were present. The defendant intended to kill another human being. The defendant did acts which demonstrate unequivocally under all circumstances that he had formed the intent and would have caused the death of the other except for intervention of another person or some other extraneous factor. Unequivocally means no interference or conclusion can reasonably and fairly be drawn from the defendant's act under the circumstances. Another person means anyone but the defendant and may include the intended victim. An extraneous factor is something outside the defendant's knowledge of the defendant and outside their control. Defendant did not actually believe the use of force was necessary, so that goes to his subjective belief. The third element of the attempted first-degree intentional homicide requires defendant did not actually believe, subjectively, in his own head, that it was necessary. This requires the state to prove defendant did not actually subjectively believe he's in imminent danger, or defendant did not actually subjectively believe it was necessary to use that amount of force. When attempted first-degree intentional homicide is considered, the reasonableness of the belief is not at issue. Whether or not it's reasonable is not at issue with respect to first-degree attempted murder in Wisconsin. You're only to be concerned with what they did believe, not whether or not it's reasonable. Whether these beliefs are reasonable is important only if you later consider the charge of attempted second-degree intentional homicide. As to your fifth count, you are satisfied beyond a reasonable doubt the defendant intended to kill another human being, and the defendant's acts. $5 from Craig Nelson. Been enjoying you and Rakita. Thank you very, very much. That's very kind of you. And thank you to all the people who are so very generous with their super chats today. And thank you to the 847 of you who are still listening to me give detailed blow-by-blow instructions of jury instructions, so we can all understand the law together. This is the fun part, people. It's been a long couple days, but I'm having a great time. I'm having a great time, and I appreciate every last one of you. I really do, and I hope, from time to time I get irritated, as I think we all do, although sometimes I don't show it, I don't hide it very well. So sometimes the chat can get under my skin a little bit. But at least today I want to let you know that I really appreciate your love, appreciate your support. I appreciate all of you being here and helping this channel grow. We're almost at 35,000 subscribers. That's amazing. We've picked up over almost 7,000 subscribers, I think, in the last 2 weeks or so. Truly, truly amazing. This has been a wonderful growth for the channel, wonderful exposure. And I really thank you all, because I'm really looking forward to not doing my day job anymore. I've been doing my day job for 14 years. I've been doing the same job for 14 years. So I think you can understand a little bit that I'm ready to try to do something else with my time. And I think that doing some commentary for a while, perhaps as a bid to become a professor, or perhaps as a bid to become a judge or something, would be fun. So I really appreciate you helping this to launch and help my career develop. It's wonderful, and I love you all. I'm past 35,000? Oh, okay. When did that happen? Hold on. Hold on. Did I? Hold on. How far past 35,000 am I? Hold on. Give me a second. Let me check the back end here. 35,173. I stand corrected. 35,173. Thank you very much for all of you here. It's wonderful and appreciated. As I was talking about it, that's cool. Let's see. Where the hell was I? If you're not satisfied, if you're not satisfied, you must not find the defendant guilty of attempted first-degree intentional homicide, and you must consider whether the defendant is guilty of attempted second-degree homicide, which is a lesser included of first-degree. You should first make every reasonable effort to agree unanimously on the charge of attempted first-degree. However, after full and complete consideration, you conclude that further deliberation would not result in unanimous agreement on the charge of attempted first degree, you should consider whether the defendant is guilty of attempted second degree intentional homicide. I'm not going to cry. I'm just a little bit tired. I'm fine. And if I do cry, then rackets can soak up the manliness all the way from Texas, as far as I'm concerned. Before you find the defendant guilty of attempted second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt of the following. Defendant intended to kill another. Defendant did acts which demonstrate unequivocally, under all circumstances, that they had formed the intent and would have caused the death of another, except for intervention of another person or by some extraneous factor. The defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or he did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on definitions of intent to kill, unequivocally, another person, an extraneous factor. The same definitions apply to the consideration of attempted second-degree intentional homicide. The third element of attempted second-degree intentional homicide requires the defendant did not reasonably believe that he was preventing or terminating unlawful interference to his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. $4.99 from Joe Calcagon. If the jury hangs on one charge but unanimously finds him not guilty on other charges, is he still exposed to those charges? No. Any charge that they resolve on should be solved. Shut up, I can cook. Geek out, love you. I must be a geek. Listening to you 5 hours, I went to sleep. Geek out. Respect. $5 from Bree. The confusion is because of the narrative format. Simple question checklist would have been clearer. That he believes his life is in danger. Yeah, we have to present it in full, fat, legal form, you know. And $10 from Nemo. Just found out about you, and you're now my favorite legal analysis channel. I like how you think, and don't just say what people want to hear. Keep up the good work. Well, thank you. I do endeavor to try very hard to give the best, fairest, honest legal analysis a simple uncivil law can be. $4.99 from David Supalivta. That a boy. I appreciate you and your channel. You'd be a great judge. Well, thank you very much. That's very, very kind of you. Where was I in the stream? This requires the state to prove any of the following. That a reasonable person in the circumstances would not have believed that preventing or terminating unlawful interference, or a reasonable person in the circumstances would not have believed the danger was imminent or of great bodily harm, or the reasonable person would not have believed the amount of force was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the belief must be determined from the standpoint of the defendant at the time of his acts, and not from the viewpoint of the jury now. As always, we cannot go beyond the moment. We must put ourselves in the moment at time. That is the facts. That is the law. Let's look at it from that perspective and not with the benefit of hindsight. The standard is what would an ordinary person of reasonable intelligence and prudence believed in this position, which incidentally, that is you, the jury. So what would you have believed in that circumstance? As to the fifth count, you're satisfied beyond a reasonable doubt defendant intended to kill, and the acts demonstrated unequivocally defendant intended to kill, and would have killed except for intervention of another person or by some extraneous factor, and the defendant did not reasonably believe he was preventing or terminating an unlawful interference with his person, or did not believe the force used was necessary to prevent death or great bodily harm to himself, you should find defendant guilty. That is a lot of stuff to keep in your head at once, isn't it, my friends? If you're not satisfied beyond a reasonable doubt defendant is guilty of attempted first or second degree intentional homicide, you must consider whether defendant is guilty of the lesser included crime of first degree reckless endangerment of safety as defined in the relevant law. First degree reckless endangerment is one who commits reckless endangerment of the safety of another under circumstances that show utter disregard. Before you may find the defendant guilty of first degree reckless endangerment, the state must prove by evidence which satisfies you beyond a reasonable doubt of the following: defendant endangered the safety of another being. Defendant endangered the safety of another by criminally reckless conduct. Criminally reckless conduct means the conduct creates a risk of death or great bodily harm to another person, and the risk of death was unreasonable and substantial, and the defendant was aware of his conduct create unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury. I as a judge, I just have to ask, like, do I personally have to read out these instructions, or seriously, can I get a text to voice bot to do it for me? Can I just go with a I'm sorry to do this. Can I just go with a, okay, Google, please read me those jury instructions? In circumstances, defendant's conduct showing utter disregard for human life. In determining whether circumstances of conduct show utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in the conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and other facts and circumstances related to the conduct. If you're satisfied beyond a reasonable doubt of each element of the first degree reckless endangerment has been proven and defendant was not acting lawfully in self-defense, you should find defendant guilty of first degree reckless endangerment as submitted. If you're not so satisfied, you must find the defendant not guilty. You are not in any event to find the defendant guilty of more than one of the following offenses. Questions 1 through 5. Using or possessing a dangerous weapon. So this is an enhancement as I understand it. So before I said like he was facing 12.5 years under the reckless charge, I think there's a 5-year enhancement. I think it might be mandatory to whatever it is. So that's a maximum of 17 years for the reckless endangerment. Yeah. The information, which is the formal criminal charge, alleges not only the defendant commit the charges in counts 1 through 5, but also he did this while using a dangerous weapon. If you find the defendant guilty on any of these counts, you must answer the following. Did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, loaded or unloaded. A firearm is a weapon that acts by force of dangerous powder. So I'd like to take note, as I'm sure many of you did, that Mr. Binger himself was using a dangerous weapon, because dangerous weapon is any firearm loaded or unloaded. So when he was pointing that at the jury, he was using a dangerous weapon by legal definition. Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon that acts by the force of gunpowder. So if it's an air rifle, not so much. Before you ask this question, yes, you must be satisfied beyond reasonable doubt defendant committed the crime while using this dangerous weapon. If you're not so satisfied, you must answer the question no. Burden of proof. We're getting close. Shut Up and I Can Cook gives me $2 to say, support this brilliant, handsome man. Well, thank you, Shut Up, I Can Cook. I will happily take my ego I'll take my ego puffed up any day of the week. I appreciate your support. Thank you. In reaching the verdict, to examine the evidence with care and caution, act with judgment, reason, and prudence, defendants are not required to prove their innocence. The law presumes every person charged with an offense is innocent. This presumption requires a finding of not guilty, unless in your deliberations you find it overcome by evidence which satisfies you beyond a reasonable doubt of guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. The state must prove it. Before you can return a verdict guilty, the evidence must satisfy you beyond a reasonable doubt the defendant is guilty. If you can reconcile the evidence, here's some reasonable doubt definitions, and these are among the better I've ever seen, to be honest. If you can reconcile the evidence upon any reasonable hypothesis consistent with innocence, you must do so and return the verdict of not guilty. Any reasonable hypothesis. If you can reconcile the evidence upon any reasonable hypothesis consistent with innocence, you must do so, and you must return a verdict of not guilty. Right? So this is not like a novel statement of law in any way. It's just very well expressed in my view. So this is like, for my mind, this is, from a legal posture, the death nail to the prosecution, because the prosecution kept saying, well, he had other options. And I suppose we could generate in our mind potential hypotheticals. We're a creative, smart group, right? So we could in our mind generate other possibilities of other things Rittenhouse could have done. I mean, if we put our thinking caps on. But we don't need to do that. We just need to find out if there's a reasonable hypothesis. Any reasonable hypothesis will be fine of what Rittenhouse did was okay. And if there's any one, all the other hypotheses in the world don't matter. We just need the one. And I think I've got at least one, so I think I'm there. The term reasonable doubt means a doubt based on reason and common sense. My friends to the left here who think he's guilty, I'd like to take a quick note at the word reason. It has to be reasoned. A reason. Right? So, yeah. And you don't need a reason to find him guilty. You need doubt beyond all reason. Or whatever the right way of phrasing that was. It's doubt for which a reason can be given, arising from fair and rational consideration of the evidence or lack of evidence. It means such doubt as would cause a person of ordinary prudence to pause or hesitate when called to act upon the most important affairs of their life. A reasonable doubt is not a doubt which is based on mere guesswork and speculation. Another note to my friends on the prosecution side. He had so many other options. Like what? A doubt which arises merely from sympathy or fear to return a verdict of guilty is not a reasonable doubt. Highlight that one for the jury right now. A doubt which arises from a fear to return a verdict is not a reasonable doubt. A reasonable doubt is not a doubt as may be used to escape the responsibility of a decision. Examine the evidence and search for truth, giving the benefit of every reasonable doubt. All of them. Evidence is, first, the sworn testimony of the witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, to which they've directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You're to decide the case solely on the evidence offered and received at trial. Disregard entirely any question the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggests that certain information might be true, ignore the suggestion and do not count it as evidence. Attorneys for each side have the right and duty to object to what they consider are improper questions asked of witnesses and the omission of other evidence which they believe is not admissible. You should not draw any conclusions from the fact that an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about that evidence. You, jurors, are the judges of credibility of the witnesses and weight of the evidence, which means that you can consider it true or not true in whole or part, and how important it is up to you. Landis Clemens says, you just made my Google Home read me the definition of jury instructions. Jordan said, defense moved with mistrial with prejudice because the state had uncompressed video evidence but gave the defense compressed. That wasn't the reason why, unless it's in their formal papers. The reason why was because of the Fifth Amendment violations, I thought. Two jurors holding out due to fear only makes sense if the majority is going to acquit. Cause supporters are likely to blame a guilty verdict on the medium BLM instead of the jury. Fair. Two questions. What do you think, from Marty McFly? Two questions says, what do you think would have happened if there was a bench trial? I don't know, man. Two, is there a hung trial? Will Kyle be released? Yep. When and up to how point? I don't know. It's dependent on Wisconsin law, how long they have to retry him. But I'd imagine they're going to get started again. Shot Pike and Cook says $2. Watch Westerns, Clint Eastwood, etc. Political. I don't really watch a lot of Westerns, no. My favorite movie of all time is Thank You for Smoking. If that gives you any sense of my personality. Smoke, smoke, smoke that cigarette. Puff, puff, puff. All right. At the beginning of the trial, I described charges against the defendant. Count 7, charging a curfew violation, has been disposed of. Oh, this is a mistake. This is a mistake because he didn't put in count 6 has been dismissed. He says the other counts have remain. Oh, geez, this is a mistake in the instructions. Oh, dear. Oh, dear. This is a mistake in the instructions. Uh-oh, danger, Will Robinson, danger. If this is really the final instructions, and I mean, they're stamped the word final, right? It only says count 7, charging has been disposed of. It doesn't say anything about count 6 being disposed. And it actually says the other counts remain. So there's a basis of appeal. There's a basis of appeal. Bad jury instructions. The jury instructions are flawed. Danger, Will Robinson, danger. Yeah, he told them count 6 was removed, but it's not in the instructions. Why was the curfew violation dismissed? The curfew violation was dismissed because the state failed to prove it was a lawful order. Stricken testimony. During the trial, the court had ordered certain testimony to be stricken. Disregard all stricken testimony. $5 from Eric Renninger. It seems so eloquently written, but how much do you think actually translates to the jury? Not that much, man. Not that much. $5 from Jacob. An exhibit becomes evidence only when received by the court. An exhibit marked for identification not received is not evidence. An exhibit received is evidence, whether or not it goes to the jury room. Remarks of the attorney are not evidence. If remarks suggest certain facts not in evidence, disregard the suggestion. Consider carefully the closing arguments of the attorney, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide your verdict upon the evidence under the instructions. The court has taken notice of judicial facts, and you're directed to accept them as true. The state has introduced evidence of statements which it claims were made by the defendant. It is up for you to determine how much weight, if any, are given to each statement. Also, incidentally, whether or not they were actually made by the defendant is also up in the air, right? Because you're the trier of fact. So you don't have to believe they're made by the defendant at all. So that seems like a mistake in some way. In evaluating, you must determine whether the statement was actually made by the defendant. Only so much of the statement as was actually made by a person may be considered evidence. Maybe made by the defendant instead. Whether the statement was accurately restated here at trial, whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of the statement, along with other evidence to determine how much weight, if any, the statement deserves. Weight of the evidence. The weight of the evidence does not depend on the number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of another witness, or even of several other witnesses. Right. It's up for you to determine how much each witness is worth, and one witness might be worth a lot compared to other witnesses. In weighing the evidence, you may take into account matters of common knowledge and observations experienced about the affairs of life. Ordinarily, witnesses may only testify about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining weight to give to this opinion, you should consider the qualification and credibility of the witness, the facts upon the opinion is based, and the reason for the opinion. Opinion evidence was received to help you reach a conclusion. However, you're not bound by any witness's opinion. Damn straight, man. That's what makes you the trier of fact, right? You don't have to agree with the experts. Credibility of the witness. It's for the jury to scrutinize and weigh the testimony of witnesses and to determine the evidence of the weight of the evidence as a whole. You are the sole judges of credibility, that is, the believability of the witness and the weight to be given to their testimony. In determining credibility of each witness and weight to give the testimony, consider the following. Whether the witness has an interest or lack of interest in the result of this trial. The witness's conduct, appearance, and demeanor on the witness stand. The clearness or lack of clearness in the witness's recollection. The opportunity the witness had for observing and knowing the matters on which the witness testified. The reasonableness of the witness testimony. The apparent intelligence of the witness. Bias or prejudice, if any, that had been shown. Possible motives for falsely testifying, and all their facts and circumstances during the trial which would either tend to support or discredit the testimony. Then give the testimony of each witness the weight you believe it should be received, which technically can be none. The defendant has testified in this case, and you should not discredit the testimony just because the defendant is charged with a crime. Use the same factors to determine credibility and weight of the defendant's testimony you have used to evaluate the testimony of any other witness. Fair. There is no magic way for you to evaluate testimony. Instead, you should use your common sense of experience. In everyday life, you determine for yourselves the reliability of things people say to you, and you should do the same things here. Evidence has been received that 2 witnesses in this trial have been convicted of crime. This evidence was received solely because it bears upon character for truthfulness. It may not be used for any other purpose. Now, members of the jury, the time has come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the juror, selected for this most important duty. You will not be swayed by sympathy, prejudice, or passion, or political beliefs. You will disregard any opinions which you may have regarding what you believe to be my opinions on the guilt or innocence of the defendant. You will disregard the claims or opinions of any other person or media or social networking site. You will pay no heed to the opinions of anyone, even the President of the United States or the President before him. The founders of our country gave you and you alone the power and the duty to decide this 9+ case. That's a typo. That's a typo. To decide this case. Decide this case based solely on the evidence presented in this court. You will fearlessly keep faith with those who entrusted you the fair rendition of justice and protection of our freedom. You will be very careful and deliberate in weighing the evidence. I charge you keep your duty steadfastly in mind as upright Americans render just and true verdicts. You will decide only whether the defendant is guilty or not guilty of the offense charge. Any consequence of your verdict are matters for the court alone to decide and must not affect your deliberation. It is for you to decide whether the defendant is guilty or not guilty of each offense charge. You must make a finding as to each count of the information. Each count constitutes a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count may not affect your view in any other counts. This is a criminal, not a civil case. Therefore, before you reach a verdict, which may be legally received, the verdict must be unanimous. In a criminal case, all 12 jurors must agree in order to reach a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you're deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it's important that you communicate with the court only by written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you've agreed upon your verdict, have it signed and dated by the person you've selected to preside. After you've reached a verdict, the presiding juror will notify the bailiff if a verdict has been reached. Everyone will return to the courtroom. The verdict will be read in open court. The court may ask each of you if you agree with the verdict. And that brings us, thankfully, to the end of these jury instructions. It took us an hour and 50 minutes to read them and explain them. And if anyone really kept consciousness through that entire experience, I applaud you, because that was a lot of stuff. It was a lot of stuff, but there are 819 of you who kept along to the very bitter end. So I really appreciate that. There were a couple things more from the Super Chats. Marty McFly says, if the instructions are shit, you must acquit. I think you can acquit for other reasons than the instructions being a problem, Marty, but your sentiment is appreciated. $5 from Tim Massey. Why on earth is this judge not sequestered? The commentary on the stream during the trial has been great. Keep up good work. The reason the jury is not sequestered is because sequestering comes with consequences, practical and collateral. So when you sequester a jury, that first of all requires you to actually do it. So you have to find a place to do that. You have to find people to, protect them in the place, bring them to and forth, monitor their phones or their mail or their whatever. And, so there's an administrative burden. There's a cost burden, because obviously there's some cost incurred on that. But probably more important than all those is the psychological impact on the jury. When you keep a jury sequestered, or even on the jury pool, by having the jury not kept there at a hotel, for example, they're free during the night. So to the extent they need to care for other people, they have some time to be able to do that. So they might be able to provide care and aid to other people. So that doesn't unduly limit your jury pool. Also, because there's a psychological effect, right, from being kept up for long periods of time. And it's also a liberty interest. It's in imposing on the people's freedom. They didn't do anything wrong. So, all that stuff. So that's some of the reasons why it's very disfavored, because it's a liberty interest of the jury. It's burdening them psychologically, may pressure them to make decisions that they shouldn't make. It's not free. $5 from Shut Up I Can Cook. What do you think the founders would do with this? I don't know. Shut Up I Can give me $2. Give us a comparable case with your analysis. No. I think that's from Size on 2, not Cut Up You. Yeah, no, I'm good right now. Skies on 2 says, nice job. Quite interesting, though grueling. Well, thank you. Thank you. Yeah, thank you. So I'm not going to answer anything that are not super chats today. I do make every effort to read the super chats, and we do have a bot to try to capture questions. But I've been here an hour, 50 minutes. It's been almost 2 hours. I'm tired, as you know, and I got through the entire thing, and I did my analysis, so I'm afraid no questions from the bot today. I guess it's one of the benefits of the super chats, right? When you have a super chat, I make every possible effort to read your question because I appreciate the financial support. Everything else is just gravy. Dragons Snore 2009 says that 9+ case tape was somehow got past the proofreader, I imagine. Yeah, all that good stuff. So I'm going to sign off for now. First of all, I want to say thank you to all the new subscribers who are here. I really, really appreciate that you're here. We have new videos coming out soon. I have some videos I need to edit, incidentally, but I have a new computer to help me with the editing. So I'm going to find some time and edit. I'm not sure when that's going to be. But if you subscribe, you'll get access to these videos I've created with potentially new and interesting backing tracks and music and stuff as I experiment around. Ooh, ah. So please remember to subscribe if you haven't done so already, and thanks to all the new subscribers. Did you hit the like button? Please hit the like button. The like button likes you. I asked. It told me. It was embarrassed, so it didn't want to tell you itself, but the like button likes you. So I'd really appreciate it if you, gave it a little like back. Yeah. And did you know that for 99 cents, you too can become a member of the channel and become an uncivilian? It's true. For a mere 99 cents, this is possible. All you have to do is hit the join button or hit the link that StreamBot is telling you about from time to time to become a member. And for 99 cents, you get a cool little icon by your name. You get to call yourself an uncivilian, and you get to look down your nose at everyone else who is inferior to you. You get to have that air of superiority and look down your nose and be like, those lowly people, they're not up here with the uncivilians, where they could be but for a mere 99 cents, but they're not. We are the chosen ones. You get to do that. So I'd recommend that to you. $5 from Nate Jacob gives me not a question, just want to let you know, enjoy the screen. $5 from Chris D. Very good. I hope all is well. Till later, my friends. I'm going to sign out. Cheers and goodbye.